Hello and welcome. This program is AI and the Law. A wild, wild ride begins, and that's no understatement. AI is looking to test the laws, the legal frameworks of the regimes we practice in, as well as how we practice in a way more significant than anything that's happened in at least a generation. I mean, the technology blossoming here is simply profound. I'm Peter Afrasiabi. I'm an intellectual property partner at One LLP, where we specialize in copyright, patent, trademark, right of publicity litigation. And today's program is going to walk through AI and where it's hitting some of those areas of the law. Let's start here. Check out this picture. If you thought that the internet and Napster was a radical test of the law's boundaries 20 odd years ago, when the internet first emerged and we suddenly could get digital music across platforms and suddenly, have massive access to our music, we didn't need our tape decks and CDs and trying to copy, a CD to a tape deck and all that. If you thought that was a big deal, that was genuinely nothing for the law compared to where we are now. Try this out. Those pictures you see there were created at nightcafe.studio. This is an artificial intelligence database machine. And what I did is went there and I simply entered a query in the search box. Now I picked fantasy art as the motif. There's different kinds of art motifs you can pick, but I just said fantasy art. And I gave the artificial intelligence system the following. Create an image of a rock star at a concert with a crowd. And boom, that's what I got. Literally, these were created by the artificial intelligence bot, for lack of a better word, just based on that simple prompt, and this happened in seconds. This is a staggering example, and we're going to go through several of them today as we suddenly explore what this means for the flourishing creative arts fields, for us as lawyers, and we're also going to start looking at other impacts on right of publicity, as some of the other technologies that are not just picture-based, but are word-based or even voice-based. So let's take a look at our overview so we get our framework set in terms of where we're going and what we're doing today. We're going to start the module by really talking about what is AI exactly, how does it work, how is it impacting lawyering already, definitional really. We need to get some working definition, working understanding of the deep complexity that sits beneath this. Now, this will be given at a high level. This is not deep engineering, artificial intelligence, computer source code type conversation, but we need a working understanding at least of what is happening, how it is happening, because this is all going to be filtered through the legal system, whether it's through copyright law, patent law, contract law, right of publicity law, to understand what is going on. And so that will allow us also to get a broad general overview of some of the legal issues that get triggered by these emerging AI applications in the world of copyright, right of publicity, and patents in particular. We're going to look at and ask kind of a fun question. Here's the question. Can AI databases be trained to essentially make the next Beatles-esque song? For example, can they listen to enough Beatles music so that they can create organically a song that's evocative of the Beatles, maybe even sounds like Lennon and McCartney? And the question then will be, if they can do this, and advanced answer, it appears they can, and if not already, they will soon. Then we get into really fascinating questions of copyright and right of publicity to figure out, is it lawful? There are already some existing cases and litigation underway dealing with these AI databases that have just come out in late 2022 and early 2023. We will even look at the current federal regulations from the Copyright Office, which has been scrambling to address artificial intelligence, and as of March 2023 at least, has issued some federal regulations and guidance for practitioners in terms of what kind of creations from AI will be copyright worthy or not. And we'll end by looking at some really fascinating, interesting, could even call them fun, fundamentally practical hypotheticals at the end of this program to walk through that really look at possible legal issues that we confront as lawyers for perhaps our own firms, but certainly for our clients too, in terms of the interplay of AI and the practice of law, because there's a lot that we can do if we start using AI to affect the practice of law, and it raises a lot of big, complex questions. Let's get started though here. What is AI exactly and how does it work? So these bullet points you see on this slide really are some bottom line, baseline explanations, but we need to walk through them. AI is an advanced computer learning based on algorithms with human-based reinforcement learning, feedback, teaching that augments then the subsequent machine learning. The result is that you can create this AI computer system that's able to complete tasks that fundamentally would otherwise require human cognition. And so one of the techniques that's used is known as diffusion. And basically this is where software can generate an output based upon inputs. And this can be for creating, for example, digital images, like we saw in those pictures in the beginning, or written content. So if we think in the context of images, for example, the way it works is the AI system is given an image in the beginning, and then it progressively alters that image through a series of steps, just changing it, bit by bit, until it's fundamentally different. And then it does the same in reverse. This is called noise. And then AI learns from these minute changes that are done to make connections between the data sets, right? To make the connection between this picture and then a morphed version of it, and what is the difference? In very, very simple terms. And then it can generate an output. Now, one example of this, the one that you probably all have heard about, is ChatGPT. It's incredibly cool, it's incredibly fun, it's mind-blowing, frankly, to go play with it. If you've done so, you already know. If you haven't, I'm going to give you 3 or 4 examples in a minute of the types of things you can do with ChatGPT. And if you haven't, it's really worth getting on there, creating an account, start using ChatGPT and seeing what it can do. It's just amazing. Here's what GPT stands for. It stands for Generative Pre-trained Transformer. Now, what that means is it's a language model that uses machine learning techniques to create human-like text in various forms. So ChatGPT right now, as you use it, is fundamentally text-based. And the way it's built is it's been built and trained on a massive data set of content. And it uses that to predict words and sequences, to develop learning from complex data patterns and natural language learning. Now, because it was trained on 500 billion tokens, and there are some advanced versions of ChatGPT that perhaps people think may have been trained on trillions of data, pieces. This then allows the language models to more easily assign meaning and predict plausible follow-on text. And, at its core, what it does is it takes words, it may map them to what are known as tokens, and longer, more complex words could get multiple tokens. Tokens are about 4 characters long, and through this complex process, you are able to sort of assign algorithms and do predictive learning. So ChatGPT neural network has 175 billion parameters or variables that allow it to take a given input that you pose into it, and it's really just you pose a question, and then based on the values and the weightings that have been given to the different parameters, and with a built-in small amount of randomness by design and intent, it can give you an output based upon what the machine believes best matches your request. And this predictive answer is a function of the algorithm and what ultimately is cognition-based thinking. Randomness, you question? Yeah, that's exactly the case. The exact same question posed by 2 people can and will get slight variations in answers because the system runs the prompt through this system each time anew. It's not simply storing an answer in a database and then regurgitating it. This is what's particularly fascinating about it. Now, is it possible to get direct copying? Yes, it is. And so you could, for example, go in there and ask it to identify who you are and what you do for a living, and it could conceivably just draw some content from your online bio verbatim, which is going to get us to some of the copyright questions in a little while. Let's, though, for those of you who have not used ChatGPT and you're scratching your head saying, wait a second, I can put in a question and get an answer, isn't that like Google? Let's take a look on the next slide so you can see how this is Google on steroids times 10 times 100. Let's check out the first one. This is an example of basically how AI training works, and this comes from ChatGPT. And as you can see on this sort of slide, Step one, they collect demonstration data and then they have a training supervised policy. So a prompt is sampled from a data set. A human labeler will demonstrate the desired output behavior. This data then is used to fine-tune ChatGPT with supervised learning. This process goes on and on and on and on and on. Then in step two, you get comparison data and you train a reward model. And so you can see that a prompt is created, several model outputs are sampled. A labeler ranks the outputs from best to worst. This data is used to then train the reward model. And then it's optimized in step three by a policy against the reward model using the reinforcement learning algorithm. And so a new prompt is sampled from the data set. The model is initialized from the supervised policy. It generates an output. The reward model then calculates a reward for the output, and the reward is used to update the policy. This very complex process over billions of pieces of data allows, let's check it out. Here's our first one, the following to happen. This is a query that I put into ChatGPT. This is our first one. I literally typed in, prepare a sample copyright assignment agreement. And boom, what you see on the screen is exactly what was the exact output I was given. Verbatim. In the beginning, as you note, what's particularly interesting, it tells you, this is a sample copyright assignment agreement, shouldn't be used as a substitute for legal advice, consult a licensed attorney in your jurisdiction before drafting or signing. That was particularly interesting to me, that was the output that came from it, but I suppose it wants to make very clear it's not offering legal advice. But I'm not going to read this whole copyright assignment agreement to you, but I will tell you this, it's a pretty decent copyright assignment agreement. It gets you 75% of the way there as a lawyer if you're trying to look at assignment issues. That's a pretty remarkable thing to be able to be given and generated that kind of an output. Now let's take it up another level. Here I queried to ChatGPT, as you see on the next slide, the following. Draft a short story about a dog and a cat who get in a fight, but then learn to get along. And quite literally, the ChatGPT spooled and then started outputting this story. I'm not going to read you the story, but you can read the story, and I think you should offline when this program's over, because it's pretty impressive that it could generate such a story that's got a bit of a plot to it and a bit of an explanation that actually addresses this situation about a dog and a cat who fight, but then fundamentally, eventually learn to get along. It's got a beginning, a middle, and ending. It's got text, verbiage, communication. It sets up a problem and then it solves the problem. This is now complex cognition in a pretty significant sense that shows just, and we're in the beginning of AI, it shows where we're going and what's going to be happening in the coming years. Here's the next one. Query to ChatGPT, I told it, write a song that sounds like the Beatles, but is new. And the output was this. I got a verse, a chorus, a verse, a chorus, a bridge, a chorus, and an outro. And the verse one, walking down the street, I'm not going to sing it because I would not be able to do any justice to Lennon or McCartney. The sun is shining bright, the world is moving to a beat, everything feels right. But then I saw you standing there, my heart began to race and knew that I had found someone to take my place. And so if you read this whole song, I read it and I said, yeah, look, this was evocative of Beatles lyrics to me. The next level would be to hear the music and to hear someone that sounds like Lennon and McCartney singing. And we'll talk about that in a little while in terms of other AI systems that can start doing this type of advanced cognition. But this is a type of thing that you can get. Now, there are limits, of course, and because we are in the beginning stages of what is going to be a long AI process, obviously, as AI works with humanity to sort of, as we start creating these systems in further ways. But if you look on the next one, here's another query I prompted. And this one, you could look at this query and realize that the prompt I gave is more conceptual and complicated. My prompt was, and if for those of you who don't know the band Joy Division, which later became New Order, if you're a kid of the 80s like me, you may have loved New Order like I did. The precursor band was Joy Division, and the lead singer was a guy named Ian Curtis who committed suicide in the late 70s. And so my prompt to ChatGPT is, what would Ian Curtis of Joy Division look like today if he had not killed himself? And you see, I got a pretty decent response. It's not really dead on, but it certainly is remarkable in terms of the ability to sort of comprehend my question, conceptually understand that what I'm posing and talking about, and generate a bit of an answer in terms of, his hair would have thinned and grayed with age. He may have experimented with different hairstyles or clothing. He had dark brooding eyes and angular features. It's able to understand what he looked like and give some explanation a little bit about what may have happened, but then also note that we could only speculate. So there you see this is an example I thought of, one that's good in terms of showing there are limitations to the cognition algorithms that are obviously present. It can't do everything, but it's getting you this one probably 30-40% of the way there. And wait until you can, which will probably happen in short order, we'll be able to punch that into a different search engine that can take a photo of him and just age him, and with predictive algorithms in terms of aging, which, those types of things have been around for a while, and just give you an output picture. All right, so let's get started fundamentally. And since we've been talking about ChatGPT, which comes from an entity called OpenAI, let's talk about the terms and conditions, because one of the first issues that we as lawyers have to confront is when we're dealing with any of these AI systems that we go to, we register, we create an account, and there are terms and conditions. There's a contract that we're entering. And so those are very, very important things to read to understand exactly who owns what. If you've seen some of my other programs from our Curious Lawyer series on social media and the like, you'll know that the terms and conditions in the social media sites are of massive significance. No one really tends to read them, and they have profound implications for copyright law and ownership of content and creations. But here we look at AI's ownership provisions, and this is a direct quote from their terms and conditions. Who owns what? And so here you can see it's fascinating. You may provide input to the services and receive output generated and returned by the services based on the input. Input and output are collectively called content. As between the parties, to the extent permitted by applicable law, you own all input. Subject to your compliance with these terms, OpenAI hereby assigns to you all its right, title, and interest in and to the output. This means that you can use the content for any purpose, including commercial purposes such as sale or publication, if you comply with the terms. So that means that little short story about the cat and the dog that you just looked at earlier, lo and behold, I own that. I could go, I suppose, publish a children's book on a short story about a cat and a dog, sell it, and if that book makes money, it's my money. OpenAI doesn't, get it. Now, don't run off and start creating stories just yet, because we're going to get to some of the copyright issues that could well be lurking in here in terms of danger points for lawyers and for our clients. But one of the issues it also notes is that you're responsible for content, including for ensuring that it does not violate any applicable law or these terms. Now, here's what it also says. Similarity of content. Due to the nature of machine learning, output may not be unique across users and may generate the same or similar output for a third party. For example, you may provide input to a model such as what color is the sky and receive output such as the sky is blue. Others users may ask the same question and receive the same response. Responses that are requested by and generated for other users are not considered your content. So this is going to create, as you can immediately see, very complex issues, because multiple people could ask the same basic question, get very similar answers, and they each may own their answer. Maybe someone else asks for the same short story as I did, or the same kind of short story, and they get a relatively similar one. That is going to raise a whole bunch of complicated questions, as you can imagine. Now, one of the key points here also is that OpenAI expressly disclaims any warranty that the output is free of, infringement, that it's not infringing. This is very important, because what this means and what this gets at as we start talking about AI and copyright on the next slide here is we have to start raising the question and asking the question, are we sure that what is being given to us is free of infringement? The machine learning has learned on something. What if what it's spitting out is someone else's pre-existing work? Now, before we get to that question, let's answer a threshold question, which is, who's the author? Take that short story we looked at. Who's the author of that for copyright purposes? Well, federal copyright law dictates and controls who's an author under the Copyright Act. And the fundamental rule that comes from 17 U.S.C. 101, and which is a Copyright Act, and the definitions under the Copyright Act, is that the term author, that's used both in the Constitution and the Copyright Act, excludes non-humans. This goes back to a fundamental case from the 1800s with another nascent new technology of the time, photography. So in the case of Burrow-Giles versus Cerrone, you have a defendant that was accused of making unauthorized copies of a photograph. And the defendant said, hold on, copyright protection to photographs can't exist because a photograph is not a writing or the production of a human author. Instead, this machine, this camera, created the photograph. Now, the Supreme Court disagreed, saying that there was no doubt that the Constitution's copyright clause permitted photographs to be subject to copyright, so far as they are representative of original intellectual conceptions of the author. And so what the court did was define an author as he to whom anything owes its origin, the originator, the maker, one who completes a work of science or literature. So it repeatedly referred to such authors as humans, describing authors as a class of persons, and a copyright as the exclusive right of a man to the production of his own genius or intellect. And so the question then is that the human sets up the camera, uses a camera, poses the people, decides on the light, the setting, the angle, and all that, and that is the human ingenuity. The fact that a machine may then snap a snapshot of what's seen doesn't deny the human authorship of that photograph. So the question we now have to ask is, if a camera is used by a human, can create copyrighted work, what about artificial intelligence? Well, let's take a quick look at some cases that have dealt with the issue of non-human authors in copyright law. And we're going to look at ghosts and spirits and monkeys. And so the first case, both come from the Ninth Circuit. For those of you not in the Ninth Circuit, you probably say, who knew? I knew it. But in any event, the first case is Urantia Foundation versus Kristen Mahara. And this is reported at 114 F. 3rd 955. This is from 1997. And so this is a copyright infringement claim between two parties over a book. And this is a Urantia book. And the defendant, selling copies of this book claimed that, no, the plaintiff can't sue me for this because the Urantia book was fundamentally written by divine celestial beings. Quote, and this is from the case, the divine counselor, the chief of the corps of super universe personalities, and the chief of the archangels of Nebadon. And so what the defendant said is that celestial beings created that content, and this was simply transcribed by humans. And so this wasn't even worthy of copyright protections. The Ninth Circuit held that, a book containing words that were indeed authored by non-human spiritual beings, wouldn't constitute copyrightable works, but they can constitute copyrightable works if there's human selection and arrangement for those apparent revelations. And so this is the quote from the Ninth Circuit. At the very least, for a worldly entity to be guilty of infringing a copyright, that entity must have copied something created by another worldly entity. So the Ninth Circuit basically said, even if those words came from, celestial beings, a human entity transcribed them, put them down, created a selection and arrangement of those words, and that's enough for copyright protection because a human did in fact touch it. So that's our first case looking at non-human authorship. The second one is, you see there, Naruto the monkey. You may have heard about this case. That's a selfie taken by that monkey. And apparently, those types of monkeys, it may look like the monkey's smiling, but apparently those monkeys make that smile, what we would, I guess, anthropomorphize as a smile, but that grimace with their face and their teeth, when they are seeing enemies and they're threatened and they're trying to sort of telegraph, back off, let's get ready to fight, whatnot, right? So the monkey was apparently holding this camera. It was turned around. He saw his reflection and, triggered that reaction of, okay, I've got an enemy or something hereby. In any event, the monkey took the selfie. And so this case ended up being litigated in terms of, at one level, the issue of, could the monkey be the author of that work for copyright purposes? And it was a case that ultimately the Ninth Circuit held that a monkey selfie could not belong to the monkey as the author because an author has to be a human being. And so that is the fundamental holding at some level of copyright law, as extant copyright law, at least today, given the Constitution and the Copyright Act. So the bottom line is that works have to be a product of human authorship. We see these examples in terms of where there's enough human authorship in one to create copyrightable works and where there's not in another. So let's take a look at the Copyright Office that has now come down with some regulations defining who owns if AI creations, if anyone. First point here you see is the Copyright Office has long held that it will not register works produced by a machine or mere mechanical process that operates randomly or automatically without any creative input or intervention. Now, in their 2023 guidance, this is what the Copyright Office has said. Works containing AI-generated material, the Copyright Office will look to whether the AI contributions are the result of mechanical reproductions or instead an author's own mental conception to which the author gave visible form. It will depend on the circumstances each time, particularly how the AI tool at issue operates, how it was used to create the final work. This is a case-by-case inquiry. So what this means, as you see on our next slide here, is that some works may get protection, some not. So here's one example the Copyright Office gave. When an AI technology receives solely a prompt from a human and produces complex written, visual, musical works in response, the traditional elements of authorship are determined and executed by the technology, not the human user. When an AI technology determines the expressive elements of its output, the generated material is not the product of human authorship. This is a very important premise that's coming from the Copyright Office. And if you go to that very first example I gave with my prompt for a short story, I didn't create any of that content, the names of the characters, of the cat and the dog, who they said, what the plot was, what the dialogue was, the story elements, the mood, all of those things that humans normally create when we write short stories. I didn't do it. I just gave a prompt. And so this would be an example where my output, the Copyright Office, under its current guidance, would say that's not the product of human authorship. It was entirely generated by the AI, so it cannot be, I can't register copyright in it myself, and the AI, I couldn't register it under the name of the AI because the AI is not a human. On the other side of the ledger, a work containing AI-generated material will also contain sufficient human authorship to support a copyright claim. And so here the example we give is where a human may select or arrange AI-generated material in a sufficiently creative way that the resulting work as a whole constitutes an original work of authorship. So you could imagine, for example, if I take that short story that was spit out by AI in the beginning, and I start adding to it and changing the arrangement of the content, I change some of the dialogue, I maybe add a couple scenes to it. I have now modified that work in a sufficient way that I have created some human authorship to it, and at least my human authorship could then constitute copyrightable work, or perhaps even just the altering of the selection and arrangement of the work that wasn't even created by me, such that you could get copyright protection perhaps on only the selection and arrangement. So, who owns that rock concert picture in the beginning? Well, under those terms and conditions, I guess I own it. But from a copyright perspective, no one owns it because I simply punched in a prompt and a system created that artwork. I didn't create it at all. So from a copyright perspective, no one. So the bottom line inquiry here is going to constantly be, to what extent did the human hand have creative control over the work's expression? Let's take a look now at some existing AI copyright lawsuits against AI entities that are already in the courts. And these were as of early 2023, really. The first one is Getty versus Stability AI. Stability AI is a platform like ChatGPT. It's another AI platform. This is an image-based one. And so this lawsuit was filed in Delaware. And Getty basically alleged that Stability took 12 million of Getty's images to train its AI image generation system. And so you can imagine that AI generation system that can create pictures that we looked at in the very beginning of this program, it has to learn on a body of material. And what Getty is saying, as against Stability at least, is that Stability has learned how to generate a picture of a person at a rock concert or a cat flying a kite, whatever. You create it, you name it, it'll generate a picture of that, right? But in order to do that, it had to learn by sitting on a database of images. And so the claim is that those 12 million images that were used to train the system were either unlawfully copied and reproduced, a violation of the Copyright Act itself, or that even if they were licensed properly, the subsequent output's a derivative work that comes from them and so is infringing, because the right to create a derivative work from an existing stock of content belongs to the original author. Anderson versus Stability in January 2023. This one's filed in the Northern District of California by artists. It's a class action. basically saying that the AI system has literally acquired billions of images to train its AI systems to then create the works. And so that's another case. These cases both raise incredibly complex fact questions, as well as massive fair use questions as to if the works were there and allowed to be used. Was the training itself legitimate, or was there improper reproduction going on? And then incredibly complicated questions about derivative works, right? Because you need to figure out if this output is a derivative work, it's derivative of what exactly, which is very, very complicated. When it's trained on 5 billion images, you need to tie it to a given image. And so you can go look at the complaint there, and the complaint's fascinating to look at. It's really well done in detail in terms of explaining AI and the systems and how they're working. And so if you want to peel the onion back a little bit more to understand these complex AI systems and the training of them in more detail, you can go to that link and look at the complaint. Here's another one, and this is in the non-image context. And this is an existing, again, copyright lawsuit that's been filed against Microsoft. It's been filed anonymously as a class action. It's Doe versus Microsoft. It's again in the Northern District of California. And this suit is alleging that GitHub, and that's a company GitHub Microsoft acquired. So the GitHub Microsoft AI program called Copilot, and that's in the system that is called Copilot, trained on billions of data points. It discerns patterns, and then it can generate answers to prompts, much like the AI systems we've already talked about. And this one is built around, and the submodel is called the Codex model, and this allows one to create code. So I'm not a computer programmer, but if you are, there are systems like ChatGPT where you could, or this Codex model, where you could prompt it to give me some code in this language that could achieve this function. And it can spit out code for you that you could then use if you're a computer programmer to put into your database that you're programming or whatnot and achieve that given function from the code. And the AI systems can now actually generate code to achieve desired functions. And so the plaintiffs in this suit are alleging that the output code is often nearly identical to extant code written by them. Now, the defendant's position is that it's all open source and much of the code is the same anyway. And again, you can see in this case, hugely complex proof issues for class cases, hugely significant copyright issues revolving around open source code out that's public domain versus non-public domain code, then code that, how much of the code is copyrightable for very limited functions, these types of very, very complex questions. But these suits are already underway. Now, let's get to our more advanced AI question, and this is sort of the Beatles question we posed in the beginning, and it turns out, and you don't even have to go to the Beatles, you can go to Drake, because some of this stuff has already hit the internet, hit the musical recording artists and their labels already. And so this is AI, kind of the next level where it creates music to sound like others. And this is really where we start seeing copyright and the right of publicity starting to converge. So in April 2023, there was a big Drake controversy, and here are the basic facts. A song that sounded like Drake's music was released. The song was called Heart on My Sleeve, and this was by AI Drake. The song was apparently created by AI to simulate music of Drake. It was viewed, listened to millions of times in days, and Drake and the music label sent takedown notices to the digital platforms to try to get the song down. It's down in many places, but as of this recording, you could still listen to this Drake song, Heart of My Sleeve, if you go on Google and punch in a search, because it's not down everywhere. And this really raises big right of publicity, advertising, trademark issues, obviously, and copyright questions that let's now unpackage. So let's start with a quick overview of copyright as it relates to voices and music. And so when we're talking about music, there are two aspects to copyright. One is the musical composition itself. You have a copyright in the lyrics and the melody, and that's the musical composition. And then the other aspect to copyright is the actual sound recording made of the lyrics and melody. And so this is the artist's actual singing and creation of the music. And each are actually distinct copyrights. And it's important to keep that in mind as we're thinking then in terms of where copyright attaches and what exactly is copyright attaching to. Now, let's talk about sound-alikes a little bit. And here's the Federal Copyright Act, and this is Section 114 of Title 17, the U.S. Copyright Act, and it provides the exclusive rights of the owner of copyright in a sound recording do not extend to the making or duplication of another sound recording that consists entirely of an independent fixation of other sounds even though such sounds imitate or simulate those in the copyrighted sound recording. And here you see the House report that accompanied the passing of this statute from the 1976 Copyright Act, where the House said, the mere imitation of a recorded performance would not constitute a copyright infringement, even where one performer deliberately sets out to simulate another's performance as exactly as possible. In other words, sound-alikes are okay under copyright law. So let's take a look at an early case that kind of dealt with a sound-alike type situation. And this is Sinatra versus Goodyear Tire and Rubber. And this is from the Ninth Circuit in 1970. Let's get the facts down, then you're going to watch a quick commercial for a minute. And so basically, Goodyear used this song, These Boots Are Made for Walking, in a commercial. And Sinatra was unhappy. Nancy Sinatra said that, that song's associated with me. The song itself has acquired a secondary meaning as being associated with me, and so she claimed under California law it was protectable. Now, they didn't use her voice singing it. They used a sound-alike, and they had a video that's evocative. So let's check out the commercial here for 1 minute on YouTube.
What are the hot cars wearing this year? Boots. Wide boots, GT tires from Goodyear.
These boots are made for rolling wherever cars are hot. Wide boots, GT from Goodyear. What sports cars need, they've got.
Check the specs. Built low and wide like racing tires. Low cord angle, 4 plies polyester cord. Track tested at 130.
These boots are made for rolling wherever cars are hot. Wide boots, GT from Goodyear. What sports cars need, they've got.
If you drive a high-performance car, you need Goodyear's finest high-performance tire.
There you go. So Nancy Sinatra was unhappy, basically saying that this whole thing is too evocative of me and my performance of that song. It sounded like me. But here's what the Ninth Circuit held. It noted, first of all, that the voice sounded like Sinatra's as an imitation. For sure it did. But the court held, nonetheless, they're not in competition, Goodyear and Sinatra. Goodyear wasn't passing off its tires as her products or her records as its products. And so the Ninth Circuit rejected Nancy Sinatra's claim on the basis that you can't use federal copyright law to control your performance and preclude others from performing a song that sounds like yours, to make musical performances, in other words. And Goodyear wasn't holding it out as being performed by her. So there wasn't this encroaching into sort of like trademark type law or state passing off theories. And so this is an example then of how sound-alikes you can't control. If you're the original creator of a given sound, these boots are made for walking, and that whole feel that her video back in the day gave, she couldn't control it. So let's revisit the Drake case then. A sound-alike can create new works. You can even create sound-alikes of existing works. But you can create new works as music, even if it's evocative of another, so long as the actual lyrics, musical composition, are not copied, and so long as you don't actually reproduce Drake's original sound recordings, and so long as it's not an unlawful derivative. And so the question then becomes, okay, you have this AI system that can create music that sounds like Drake, and there's nothing wrong with a Drake sound-alike creating music. And if it creates completely new music that doesn't infringe existing Drake music, and this sounds like Drake and it's evocative of Drake because it's kind of in that style of Drake, the same way someone could create music in the style of the Beatles, like the Monkees did, for example. The question then is, can the AI systems do this? And are the labels going to be able to, and the artists going to be able to stop this? And so this gets to some of these hugely complex copyright issues in terms of, okay, how did this AI system learn to sound like Drake? Well, is that a derivative work of his existing works? Or is it not? And is this any different to really human artists who want to make music evocative? For example, you have bands that say, hey, I've listened to all the U2 music. I love U2. I've trained on U2 music. I want to make music that kind of sounds like U2, but it's my music. These are questions that, at least in the non-AI world, are pretty well answered. I mean, I have the right to go out and create music that I can't infringe U2, but I can try to sound like Bono, and I can try to create music that is evocative of U2 and try to build a fan base of, like, you know, another U2 type band. I can't use their name, and I got to be very careful about trading off, passing off on trademarks and the like, and especially staying clear of copyright law in terms of infringing their existing musical compositions or lyrics or sound recordings. But it shouldn't trip copyright laws. And so the questions then become these complex questions we were talking about in those cases about if the AI systems are allowed to train on those materials or do so lawfully without tripping copyright law, what is the answer going to be? And from a copyright perspective, the answer under current law looks, you know, and the jury is out for sure, but as a betting person, it looks like, despite the frustration of the labels, we could well have AI systems generating music. If they can get through the training hurdles legitimately, the outputs may well be legitimate material to consume. Now, where this may hit boundaries on the law to protect the artists and the existing creators would certainly be trademark right of publicity laws, depending upon how that creation is advertised and put forth. And so if it's put forth as AI Drake, there's going to be a huge problem right there, because AI Drake is using Drake's trademark now and trading off his name, you know, and whatnot. And so that this is where you start triggering right of publicity and trademark. So let's take a look quickly at a right of publicity overview, just to get really quick some right of publicity fundamentals down so we can continue working through this really fascinating current on the edge question. So what is the right of publicity? Well, it's statutory or common law in many states, but not all. And what the right of publicity fundamentally does is it protects a person against an unauthorized use of your name, your image, your likeness, your voice for commercial gain. And so the root right is this kind of personal intellectual property right of publicity, as it's known, to control ultimately the commercial use of your identity, commercial exploitation of your identity. And in some states, there's a post-mortem right, and that would require, in some states that give this post-mortem right that can last for up to 10 years to 95 to 100 years even, for the estate and the heirs to control the ongoing use of that deceased person's right of publicity. Often this is for sort of dead celebrities, what are known in the industry as celebs. And it will require generally that person's name or likeness had some sort of commercial value at the time of death. Some states even have registration regimes. So that's the big picture overview. Now, let's ask, where did this come from? I mean, this was first recognized, as you see on our slides here, in a seminal work from Brandeis back in the late 1800s, talking about the right to privacy. And this was extended in common law over time, and then it was codified in the 1970s, for example, in California. It's been codified in over 35 states. And this is a distinct right to copyright or trademark right. And indeed, the Supreme Court actually has addressed this in a famous case called Scripps-Howard, Zucchini versus Scripps-Howard in 1977. And in that case, the court found that the First and the 14th Amendments did not prevent the performer whose entire live human cannonball act, which act was recorded by a reporter and later broadcast on TV, that he was not barred from bringing a claim against the reporter and the publisher of that video of him doing his act based on Ohio's right of publicity. In other words, his persona, like he's a cannonball, he's shot out, he lands, that short sequence, that was his whole right of publicity. That's his whole, thing. And that was something that couldn't be taken and used without his consent and permission. And the broadcasting companies, of course, claimed first 14th Amendment rights to kind of broadcast this stuff. And the Supreme Court said no. The Constitution wouldn't bar him seeking protection under state law of his right of publicity. So let's unpackage this a little bit, and we'll use California as an example with its statutory right of publicity. And this is in the California Civil Code at 3344. And it protects against unauthorized uses of a person's name, likeness, voice, signature, photograph, and commercial advertising. And so you can see the statute here. Any person who knowingly uses another's name, voice, signature, photograph, or likeness in any manner or in products, merchandise, or goods, or for purposes of advertising or selling, soliciting, purchasing products, merchandise, goods, or services without consent, or in the case of a minor, the prior consent of the parent, shall be liable for damages. And so the basic prima facie case is that, is there a knowing use of someone's protected right of publicity, their identity? Was it for commercial advertising purposes? And that's an important question because, there's a difference between using Nancy Sinatra's name, right, to sell tires versus Nancy Sinatra's name to create music. And then was there a direct connection between the use and the commercial purpose? So let's take a look at a very important case of voice. And this is important because as we're talking about artificial intelligence and these systems that then can generate sound-alike voices, we have to look at existing case law that's dealt with the protection of voice under state law. So here are the basic facts before you look at this little commercial from the 1980s of Midler versus Ford, reported at 849 F. 2nd 460, and this comes out of the Ninth Circuit in 1988. And so basically here, Ford Motor Company wanted to do an ad campaign for its Mercury Sable car. And it wanted to inspire this kind of nostalgic sentiment of the 1970s, and so it wanted songs from the 1970s sung by the original artists. Now, Ford wanted Midler to sing her song, Do You Want to Dance? And this was from one of her albums. And Midler refused. I don't know exactly why, but wasn't particularly interested in helping Ford sell its cars, which is fair enough, that's her right. So what Ford did was went out and it hired a voice impersonator, to sound like Midler, and then it went out and had that person sing the Midler song. Now, it cleared all the rights to the song. Midler didn't own the copyright to the song, so it got the proper rights and followed the copyright law to create a new version of the song, Do You Want to Dance? And it hired a sound-alike. And it had the right to have a sound-alike to create a song. Now, and it didn't use Bette Midler's name or image in the commercial. But it tied her voice to this commercial product, the car. It didn't just release the song and tell people, here's a compilation album of cool songs from the 1970s being released by Ford, please buy our album, right? It wasn't creating music, it was creating a commercial, advertising with the song. So check out the 30-second YouTube video here.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated new shape to the American road.
Wanna dance?
Introducing Sable. Mercury, the shape you want to be in.
Here's what the Ninth Circuit held. Why did the defendants ask Midler to sing if her voice was not of value to them? Why did they studiously acquire the services of a sound-alike and instruct her to imitate Midler if Midler's voice was not of value to them? What they sought was an attribute of Midler's identity, and that's the key point. They were using an attribute of her right of publicity, her identity, her voice. And its value was what the market would have paid for Midler to have sung the commercial in person. The human voice is one of the most palpable ways identity is manifested. Very, very important holding that's going to have massive, massive repercussions and use as we now enter the AI age. This case is not an outlier case. There's a similar case brought by Tom Waits in the Ninth Circuit a few years later when Frito-Lay's used a sound-alike to help sell potato chips. And what the Ninth Circuit held is that the First Amendment protects much of what the media do in the reproduction of likeness or sounds. A primary value is freedom of speech and press. Thus, as this court held, the purposes of the media's use of a person's identity is central. If the purpose is informative or cultural, the use is immune. If it serves no such function but merely exploits the individual portrayed, immunity will not be granted. And so this is a very important immunity line, and it's going to get at the question of whether, then, is it informative or cultural? Is it protected by the First Amendment if you just release sound-alike music? Is that more of a cultural First Amendment protected use? Or is that going to be seen as a use that is, even though you're not selling cars or commercial products, you are selling music, is it going to be seen as being one that's not immune? Current law would say that sound-alikes can make sound-alike music, sell the music as music, couldn't use the sound-alike to sell a car because that would then start tripping the right of publicity of the original artist in terms of the protection of their voice. But these are where the open questions are, and this is where AI is posing huge issues as we enter the AI age. Here are some other examples of some of the massive right of publicity issues with new AI technologies. And so we have hologram concerts, and you already have this a little bit in Las Vegas. Michael Jackson's hologram is on show on stage with other performers. But think about this, where you will be watching the Beatles on a hologram tour, fully three-dimensional in 2100, shoot, maybe even 2030. When AI will be able to perfectly reproduce them in 3D holograms. I mean, perfectly reproduces based on learning and using, video footage of them in their existing historical performances, getting their gait down perfectly, and then it will be responsive and reflective and even be able to sort of not be fully pre-programmed. These technologies are on the horizon. We're already using them to some extent in movies. You can see this one here, this example from the Star Wars Rogue One movie, where they took an actor and they used advanced computer hologram technology, which is AI-like early type of AI technology, to create and superimpose Peter Cushing, the famous actor who's no longer alive, his face onto this other actor to try to reproduce his persona, his look. Now, another particularly fascinating place, which comes back to voice, where we see these voice technologies emerging that are really going to impact future commercials, future sponsorships, and start triggering huge right of publicity issues, come in voice. And so one example that's worth thinking about is the example of Val Kilmer. For those of you who saw the new Top Gun movie, you saw Val Kilmer in it. What you may or may not know is that he has some sort of throat, I believe cancer or another disease, that's damaged him such that he's lost his voice. And so when you see him actually speaking in the new Top Gun movie, it wasn't him, it was software. Check out this YouTube link for the next minute or so.
We all have the capacity to be creative. We're all driven to share our deepest dreams and ideas with the world. When we think of the most talented creative people, they speak to us in a unique way. A phrase we often hear is having a creative voice. But I was struck by throat cancer. After getting treated, my voice as I knew it was taken away from me. People around me struggle to understand me when I'm talking. But despite all that, I still feel I'm the exact same person. Still the same creative soul. The soul that dreams ideas and stories constantly. But now I can express myself again. I can bring these dreams to you and show you this part of myself once more. A part that was never truly gone. Just hiding away.
How incredible is that? That software was able to emulate Val Kilmer's voice. It literally has given Val Kilmer back his voice. Now, you can immediately imagine what this means. These technologies that can learn from people's speech and speech patterns, and then with an input of words, predictively give an output of exactly how that person's voice would sound. Inflection, pause, pronunciation, enunciation of every vowel, consonant, syllable, word, you name it. Those will have massive applications in the future and will suddenly be used extensively, you can quickly imagine, for potential infringement, or even not even in potential infringement, licensing. You could imagine we could have Humphrey Bogart's voice doing commercials now, if that's of value to a company that wants to go license his voice from the estate. So this is part of where these AI technologies are creating massive new issues. So let's get back to Drake on our slide here. Drake and right of publicity. If the song that sounds like Drake were released as a Drake song under his name, or implied affiliation or sponsorship by him, or advertised by him, then I certainly think there are huge trademark right of publicity issues that can be brought to put a stop to that. Or if the song were used in a commercial, so whoever the AI creator is, they said, hey, look, I've got this cool song, do you want to use this in a commercial? And the company comes and says, yeah, I want to sell Ford cars. Wow, that sounds like Drake, I'm going to use it. They would have Midler and Waits problems, wouldn't be able to do that. But the real question is, what if it's just this new band, AI XYZ band, and it doesn't purport to be affiliated with, sound like, associated with Drake? It's just releasing music, the AI XYZ band. And it's really cool music that sounds like Drake. It's evocative of Drake. The question then is that violating his right of publicity, right? And the answer would be no. That would not be a commercial use any more than the Monkees weren't infringing the Beatles, for example. Any more than Copyright Act says that you have the right to make sound-alike type music. And so the question then is right of publicity law ever going to be allowed to expand beyond that narrow immunity line that Midler gave, where Midler said, look, this use was to sell cars, that's not immune, but if it's got other cultural uses, such as making music, for example, that wouldn't be immune. And so the narrow question we're now in is, okay, if I create an AI XYZ band that sounds like Drake, is that really a commercial use of his voice, in essence, a sound-alike voice? Even though I'm just selling music, I'm not associating it with kind of commercial endorsements or products. Is right of publicity law going to allow that expansion into that zone where it then comes up against the Copyright Act's refusal to stop sound-alikes in the creation of music? And so this is where we have a collision coming in the coming years over AI. Let's do a quick sidebar here. And this is on the question of whether AI is triggering a need for federal right of publicity. And we have inconsistent state rules across the country. We've got varying rules that create forum shopping and make it uncertain where you can go. You even have some conflicting state rules where some give protection, others don't. And this creates a problem. And so we can take a look right here for about the first minute of this slide, of this YouTube video. And this is a deep fake example from Tom Cruise. And so you can see what technology can already do.
That's why. Oh. It's it's a little embarrassing. It reminds me. I was once in Russia. I ran into Gorbachev. He said, Mr. Movie Star, are you nervous? I said, no, Mr. Gorbachev, I'm not nervous. I don't. He goes, well, remember how much a polar bear weighs? I said, polar bear? He said, enough to break the ice. It's the last time I've ever seen Mikhail Gorbachev. What's up, TikTok? You guys cool if I play some sports? I love it. More for the audio experience.
So, you swear that's Tom Cruise, right? The gait, obviously the look, the sound, it looked and felt like that has to be Tom Cruise. And this is early technology, right? And so this is the type of thing is affecting people profoundly. And so with these emerging AI technologies in this space, we can create near virtual avatars. It's particularly exploitive and damaging, especially when it comes to revenge porn, and then augmented and virtual reality worlds of pornography where avatars can be created to look like particular women, for example. This type of particularly damaging use makes it, I think, all the more important that we are going to have to nationalize a right of publicity so that there's a national set of rules that can allow quick protection when you have these hugely exploitive uses of AI technology that damage people. Let's now, on our final module, get to patents. And we're going to look real quick here at AI and patents. And so an early issue is the Siemens Corp used AI to create a new car suspension. And it was an incredible suspension. It was 100% AI created. No human had done it. And they realized we can't even patent it. And so this gets to questions about patentability of AI systems. And this has been litigated in the United States in the case you see here of Thaler versus Vidal. And basically what happened is this AI system called Dabus created literally two inventions. And Thaler, who owns the system, filed patent applications and listed the AI as the inventor. And these are, you can see there, the two patent inventions. It was denied. This went up to the Federal Circuit, and the Federal Circuit held, much like the Copyright Act, the Patent Act requires some sort of human inventor, not a non-human person. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new useful improvement thereof may attain a patent, subject to the condition requirements of the title. The term inventor means the individual or if a joint invention, the individuals who created it. Now, the open question is then, if a human is listed as the inventor and conceived the invention with AI help, can it still be patented? So if you've got this kind of blended existence, to what extent did AI invent some of it? To what extent did the human invent some of it? Will some of it be invalidated? Really fun questions that are going to be litigated in the coming years. Now, the Contras in South Africa, actually the first AI invention patent has been awarded there under their patent laws. This brings us to some practical legal issues. What if I want to use some marketing content that comes out of it, or I want to publish that short story? Well, the best advice right now is don't use purported AI content if you want to be 100% safe. If you want content that you own the copyright to, create it yourself, do an assignment or work for hire agreement with someone else, or license it. But if you must use AI, morph it enough that the human hand has created something so you can feel comfortable to owning it. But remember, rear view mirror risk here. What that AI gave you that you think the AI created, maybe it has blended all sorts of stuff and has reproduced something that someone else has already created in that underlying billion-odd piece of data set. Next question. What if I need a quick contract and I get it from ChatGPT, like that copyright assignment agreement? It's actually really cool to see, and it can get you 75% of the way there. So my advice would be, you know what? They're not bad precedents to go ask for and look at and use. But give it a very, very cautious eye as a lawyer if you're going to be using that for your legal work, and go through it and make sure it's, you get it, cleaned up properly for your needs. But it was well in the ballpark, I thought, at least on that copyright assignment agreement. Next question. What if I want a set of images to go with some content I write? Here, my best advice to you is license them. These image cases, to me at least as a copyright lawyer, are ones where it feels like there may be a greater factual basis to ultimately say that that AI image is actually an unlawful derivative work. And so until this legal landscape on copyright and AI with respect to images clears up, I think it's much safer to use licensed stock images. So that image in the beginning of the rock concert, it was created by the AI system, but I wouldn't be comfortable using that image like on my law firm's website, for example, or telling a client, yeah, don't worry about it, use that image, you have no copyright problems, because I don't understand enough about how that image, if it's genuinely a new creation or if it really is a derivative work of someone's fantasy art that's out there, and you don't want to hear from a copyright plaintiff seeking statutory damages. So I'd be careful when it comes to images even more. So you see our conclusions are those. We have to be very careful as lawyers relying on those precedents as documents. It's going to test copyright, patent, right of publicity law in seismic ways. I mean, these are massive shifts coming in terms of ownership of the creation, in terms of derivative works and whether they are derivative works. The collision of right of publicity and copyright law has never been more explosive than right now, as we're entering, the third decade now of the 21st century. This is going to test the boundaries of current copyright, right of publicity law in massive ways. Probably is going to inexorably lead to the need to nationalize the right of publicity law so that we can protect people from exploitation by the AI technologies, sound-alikes, avatars, and the like. And I think fundamentally where we're going as a legal regime is that Congress is going to be pressed heavily to start addressing patent and copyright definitions of authorship and inventorship to really figure out if we're going to allow, as these technologies become more and more important, these really complex questions. Are we going to allow AI to own it? Or are we going to say, no, that's great, you use AI and they may create great inventions, they belong to the people? These are the questions we're looking at on the horizon. It's a wild, wild ride. Thank you very much.